The criticism hitting the nation's judiciary seems to be filtering to the ears of the CJN. Hence, she has resolved publicly that she will be doing everything within her capacity to correct the abnormalities we see today in the judiciary.
Decisions in Nigeria is now seen as a clear and present danger to this arm of government, undermining public confidence and threatening democracy, political stability, and economic growth. While conflicting decisions are sometimes inevitable due to the complexities of the legal system, there is frightening increase in cases where litigants obtain conflicting judgment from court of coordinate jurisdiction, which is as a danger to the dispensation of justice. Conflicting decisions either arise from genuine differences in legal interpretation, judicial overlap, or deliberate attempts to manipulate the legal system. In 2020, there were two conflicting orders of the Federal High Court in Port Harcourt and that of Edo State High Court on the qualification of Godwin Obaseki to contest the 2020 governorship election in Edo State. While the Federal High Court in Port Harcourt barred Godwin Obaseki from participating in the election, the Federal High Court in Edo cleared him to participate.
The judiciary is made of Nigerian people as well. Yes, this is a major challenge that must be addressed, but we must acknowledge the fact that it's not even just about the bench alone. So those of us who are lawyers at the bar also need to recognize the fact that we're contributing to some of these challenges. Then individuals outside, judges don't just come up with orders, they are Father Christmas, and they don't just come up with decisions. Oftentimes Nigerians, litigants, lawyers approach the court with their complaints and seek relief as the case may be.
Another case is the political impasse in Rivers State caused by the conflicting decisions of two federal high courts. Justice James Omotosho nullified the Rivers 2024 Appropriation Bill of 800.3 billion naira that has been passed by former Speaker Edison Ehi and signed into law by Governor Similayo Fubara, and directed the governor to represent the budget to Martin Amewele-led House of Assembly. However, a few hours after the delivery of the judgment of Justice James Omotosho, Justice J.O. Abdulmalik delivered a ruling ordering substituted service of the originating processes on all defendants in the suit filed by some Rivers elders to stop Governor Fubara from re-representing the budget to the Martins Amewele-led faction of the House of Assembly. The court also ordered parties to maintain status quo pending the hearing and determination of the motion expertise filed by the elders. Now, the CJN has summoned judges involved in the cases pertaining to Rivers State and set up a panel to investigate these judgments. The panel, headed by a former Court of Appeal Justice, includes two heads of courts. The summons is for the Chief Judge of the Federal High Court and judges who delivered rulings both in Rivers and Abuja in respect to the political crisis in Rivers State.
This is timely. And we would expect that something fruitful will come out of it. But I can tell you that, like you rightly noted, it is not just happening in this dispensation. If you go down memory lane, what was the reason? Before now, election petitions from the, governorship election petitions, before now it would terminate at the Court of Appeal. But presently, as we speak, governorship election petitions terminate at the Supreme Court. That is the only election that, goes through three stages: the tribunal, the Court of Appeal, and the Supreme Court. And you can imagine the money involved. Why did the Supreme Court decide to remove, the cap of the Court of Appeal? Because of the conflicting judgment emanating from the Court of Appeal. Also, if you remember in 2015, when there was the fight for the soul of PDP, it was almost a ping pong between the same Port Harcourt and Abuja. Today, one judge will give order in favor of the McAfee-led faction in Port Harcourt. The next day, another judge will give a contrary order in favor of the Modu Sheriff-led faction in Abuja. So it became a ping pong, it became a very embarrassing, and people called on the then chief judge to look into it. I remembered also that a panel of this nature was set up, And at the end of the day, it continued. You also remember election really had always been, the main problems of conflicting judgment emanating from our court, from the state high court and the federal high court, and the Court of Appeal most times. And maybe because the Supreme Court is just one court, that's why, you hardly find conflicting judgment. If you had 2 or 3 Supreme Courts, or you had regional Supreme Court and then the federal Supreme Court, I can bet you that certainly you're going to find conflicting judgment. And the reasons are not far-fetched, because certainly everything that our politicians are interested in, they pollute. And so politicians are so much interested in judiciary now because they know that this is the arm of government that determines whether they stay, or whether they remain or exit office. And so they are very much interested. And sometimes even when the position of the law is so clear, to even elementary law students, you see our courts will do judicial abracadabra and begin to, give conflicting orders. And you now begin to wonder. In some cases, you begin to ask yourself, what is the local standing of even the parties that are speaking, such order? What is their course of action? While in most cases, course of action and right of action is very elementary. But you still see parties who do not have interest in the matter, who are not members, for example, of a political party, who approach the court and ask the court to restrain activities of a political party. So I think this is timely. Like I had said, it is timely. The unfortunate part also is the fact that people are beginning to also doubt the competence of the highest court of the land to actually, mete out punishment to these persons. Not also out of place because of the quagmire we find ourselves when the Chief Justice of the Federation appoints almost every member of the NJC. Almost 85% of the members of the NJC are appointed by the Chief Justice of the Federation. So in that case, if we now have a situation where people begin to express doubt in the CJN to do justice in a matter, then they are certainly going to have a problem. But it is timely, like I said, and I have I've given them the benefit of doubt, and I do hope that this will, go a long way in stemming this tide of this judicial abracadabra and judicial somersault that we see, or ping pong that we see our judges, engaging.
So in the past now, where has this put the judiciary in public glare? What do you think, what sort of damage has all of this done to the system?
Yeah, first and foremost, I don't just want to blame the judiciary. Let's not exonerate lawyers.
Yes.
Because lawyers, even though some people will tell you that if a judge declines to grant an order, the lawyer will not file frivolous applications. And then, like Kayode Esho once said, I repeat this as often as I can. I ring a bell with it as often as I can. Kayode Esho once said that behind every allegation of bribery against a judicial officer, he didn't just say lawyer, he said there is a senior advocate who is a conveyor belt. So when you have members of the bar and the bench connive to ridicule the judiciary, because the question the layman will ask most times is that, is the law not clear? Is it not the same law? But we say the law is what the court says it is, because the Constitution is what the court interprets it to mean. If the court, the highest court of the land, has interpreted a section of the Constitution in a particular way, and then other judges begin to find a way to distinguish, the facts of the matter presently before them, then if directly to the layman, what that means is that you're bringing the institutions, the temple of justice, to ridicule. So lawyers and judges, connive in these matters to bring the temple to justice. But quickly, let me cite the case of Rivers State, without attempting to pull the wool or do the job of the the panel that has been set up. We know that by virtue of Section 91 of the Constitution, it's a clear section of the Constitution that every House of Assembly shall have at least 25 members and not more than 40 members.
Okay.
So it is clear. It is clear. Check Section 91 of the Constitution. That's the provision of the law, the ground norm of the land. And if for any reason at all, some members, whether by hook or by crook, or whether by judicial pronouncement or by speaker, if for any reason members of the State House of Assembly seats are declared vacant, and that State House of Assembly can no longer function, what is to be done is to call on INEC to conduct election. In the event that INEC does not conduct election, what should be done is to litigate the matter. But a situation where 3 members sit down and then a governor of a state will present an appropriation bill to such members is akin to the judicial ridicule that we are talking about now. It's akin to legislative rascality, executive recklessness, and toying with the lives of the people. So you do not need a lawyer to tell you that it is out of place for 3 members in a state to approve the budget of that state in clear violation of Section 91. So ordinarily, any judge that will hear such a matter, any judge at all, that such a matter is presented before, should not even be entertaining it. Also, in the case of the defection between Rivers State and the Federal High Court will grant an order. The Rivers State, even when there are clear cases of lack of jurisdiction, so it's not, and it is senior lawyers on both ends that are filing these cases. And so it brings to ridicule the institutions, and not just the institution, members of the bar and bench. And also, let me cite another example. A situation where local government election is clearly within the purview of the state's governor by virtue of Section 7 of the Constitution. And the local government election is to be conducted. Somebody approaches the Federal High Court. What is the business of the Federal High Court in the conduct of local government election in the state? But a judge will sit down simply because INEC and the police are included in the matter. A judge in the Federal High Court in Abuja will sit down and begin to grant orders. So all of these are the issues. There is no way anybody will tell the average Nigerian that there are no pecuniary gain in all of this. Because when it is so clear, it is visible to the blind and audible to the deaf, it becomes, the only conclusion the ordinary man would draw is that there are pecuniary gains somewhere. It is sad. And I think that all of this so that the panel will also, know that, like Lord Denin once said, when the judge sits on trial, the judge is on trial. The entire world, because the world is a global village now, I am in Zambia, Lusaka, and I'm talking to you in Lagos. And so the entire world will also be trying them as they are trying this matter.
Oh, okay. I was almost, I should have known because I was looking at the attire, at your lovely attire. But, back to this discussion, this issue of, citing a case that's, on all fours, it's should be cited in Rivers State, for example. But I don't know if that's also going to come under the purview of this NJC panel, because I know that in the news recently, the issue of bringing back those cases involving Rivers State back to the state and not in Abuja, where, as has been posited by Mr. Femi Falana, there are links. There is the possibility that there could be bias, looking at the fact that the FCT minister, Nyesom Wike, also has an interest. Help us to make sense of all of that, and if you think that should also come under the purview of the panel.
Does the governor not have an interest or have influence in Port Harcourt. So if you say, oh, yes, on Wike will have influence in Abuja, does the governor not have influence in Rivers State? So you see, what we should be doing is to have judges who will dispense justice no matter whose horse is gold. Justice, those people who will look at the facts of the case, irrespective of their relationship, irrespective of their political leaning, irrespective of the sympathy that they have, to deliver the dispense justice. I was at a panel session, I moderated a panel session where I had both serving and retired very senior judges, and I put a question straightforward to them to ask, have you ever been influenced, not by people far from you, by your husband or parents, to influence a matter? That's to tell you that Nigeria, we're all involved in this. And the answer was shocking, that yes, they get this request steadily from spouses, from parents, from relations. Oh, I am interested in this matter, please help me. You know, imagine your father calling you and saying, you see, please, I'm not asking you to bend the law, but see what you can do. But the decision has always been, what would you be remembered for? You want to write your name in gold in the sand of time. So if we have judges who are upright, because the same court that had ruled that the Federal High Court has one jurisdiction. So whether the Federal High Court is sitting in Warri, or whether the Federal High Court is sitting in Abuja or sitting in Port Harcourt, once people have confidence that justice will be dispensed, then there won't be any need of where the judge is sitting to be. It becomes immaterial of where that judge is sitting. But the situation where if the judge is in Rivers, the tendency that he will be influenced by the governor is very high. If the judge is in Port Harcourt, the tendency that the new landlord of Abuja, Minister Yeson Wike, will influence the outcome, you know, then we'll gradually can kiss justice goodbye and they say, you know, what we'll be beginning to build will be, you know, recourse to self-help, which leads to not only breakdown of law and order, but anarchy in any sane society. So judges, irrespective of where they sit, should be seen, like we say, justitia fiat right column, to dispense justice even if the heavens will fall, because the heavens will never fall. But this idea of pandering to, if it's Abuja, we know where the pendulum will swing. If it is in Rivers, we know where the pendulum will swing. It's not good for our democracy. What it consistently is doing is to make us, not just the judiciary now, but also members of the bar, a laughing stock. Just like I was laughing when you were asking the question that if all the cases should be moved to Rivers, definitely there will be influence from that direction too. So now where do we strike the balance? That's where the problem is, because that's what we, lawyers and judges, have done collectively to the institutions of the judiciary. And yet we say we are learned, members of the bar, members of the noble profession, and, you know, but day in, day out, we continue to ridicule that same noble profession. It is sad.
So despite all of this that you have mentioned, so what do you think, do you see a light at the end of the tunnel?
Every tunnel has a light, except the tunnel is blocked. So every tunnel has a light, except it is intentionally blocked at the other end. So that's why I'm telling you that it behoves on us, Nigerians. I told you copiously, when a judge sits on trial, the judge is on trial. What it means is that when a judge is trying a matter, the entire world is trying the judge. So it behoves on us, Nigerians, to consistently call on the members of the panel to dispense justice. If you remember, there was a time some judges were sanctioned in this country for having unholy relationship with some senior lawyers in election petition matters that they were handling. So if these judges are found culpable in any way, it shouldn't, let me say this quickly. The members of the panel should not just involve the members of the judiciary alone. We should also have the Economic and Financial Commission, Crime Commission member as a panel, and then the ICPC as a member of that panel, so that they'll do a holistic job. I know that some of these allegations of bribery are not done through account; they are done through, forex. But there would be, a holistic, investigation and, attempt to, maybe upturn dead woods and see if there is any shred of evidence. And if any is found, some persons should be used as, ready example to serve as a deterrent to others. Because whether you like it or not, politicians will always, attempt to compromise judiciary. They will compromise the members of the bar. They'll compromise anybody because of the love for power. Because we have not been able to conquer poverty in Africa, same with Nigeria. Right. So the attempt, once a few notes are thrown at some persons, integrity takes the back burner. But it is sanctions consistently as lawyers and as judges. It is sanctions that, help to maintain sanity, and orderliness in such societies.
And found worthy of the prestigious rank of Senior Advocate of Nigeria. However, while this is an occasion for celebration, it is equally important to engage in sober reflection. Although our journey has not been entirely smooth, the challenges we faced have provided us with opportunities to learn and improve. In areas where we have excelled, we will strive to raise the bar. And in those where we have fallen short, we will assess ourselves critically and move forward with renewed determination. That said, the Supreme Court and the entire Nigerian judiciary as a whole have fared well in the past legal year, thanks to the prayers, advice, and support of well-meaning Nigerians. As the new legal year unfolds, we look forward to building a judiciary that will be the pride of Nigerians, both at home and abroad. The 2023-2024 legal year, which concluded on Friday, 19 July 2024, was marked by several significant milestones. On Monday, the 26th of February 2024, the Supreme Court made history with the appointment of 11 new justices, marking the first time in recent years that the court reached its full complement. These appointments provided much-needed reinforcement to the 10 justices who had been handling the entire workload of appeals. Shortly after the legal year ended, my predecessor, Honorable Justice Olukayode Ariwola GCON, retired on Thursday, the 22nd of August 2024, having attained the constitutional retirement age of 70 years. I was subsequently appointed in acting capacity on Friday, 23rd August 2024. In the last legal year, the Supreme Court handled 1,124 cases, invoking both its appellate and original jurisdiction. These included 435 civil appeals, 269 civil motions, 219 criminal appeals, 102 criminal motions, 89 criminal appeals, and 10 originating summons. A total of 247 judgments and rulings were delivered, including 74 political cases, 92 civil cases begun by originating summons, and 81 criminal cases. This remarkable success is attributable to the dedication and teamwork of my fellow justices and court staff. The Supreme Court of Nigeria remains one of the busiest in the world, a testament to the upsurge in litigation which has kept our dockets full. Our workload is intense. We work from Monday to Friday, holding daily sittings. Wednesdays are reserved for chamber sitting to consider non-contentious matters, while Fridays are dedicated to delivering judgments and rulings. I am deeply grateful to Almighty God for giving us the strength to accomplish so much. However, I encourage litigants to embrace alternative dispute resolution mechanisms to ease the burden on our courts. The culture of litigating every disagreement and appealing every lost case, no matter how trivial, contributes significantly to the backlog of pending appeals in the Supreme Court and the Court of Appeal. This trajectory is unsustainable for a nation striving for economic development and human capital growth. Educating Nigerians on the benefits of alternate dispute resolution is a collective task for all stakeholders in the justice sector. In this regard, concerted efforts are being made to ensure that the Supreme Court Mediation Center becomes operational to make the desired impact in the new legal year. The Corruption and Financial Crime Cases Trial Monitoring Committee, chaired by Honorable Justice Suleiman Galadima, CFR JSC retired, has been instrumental in expediting the trial of corruption and financial crime cases in the country. Working in collaboration with anti-graft agencies, the committee has facilitated a significant rise in the dispensation of corruption cases. Between the 2nd of January 2024 to 2nd August 2024, the Economic and Financial Crimes Commission, EFCC, with the committee's support, secured 2,387 convictions, while the Independent Corrupt Practices and Other Related Offences Commission, ICPC, filed 54 cases and secured 11 convictions. While holding the judiciary accountable where we fall short, we should also commend the courts in deserving cases for their commendable performance in handling these cases. This is a new dawn and a new era in the Nigerian judiciary. I want to assure my fellow Nigerian citizens that we are committed to working more diligently to improve public perception of the Nigerian judiciary. Over the years, various factors have contributed to the negative image of the judiciary. However, we are determined to change this narrative and make the judiciary a source of pride for all Nigerians. When the legal compass of a nation falters, everything suffers, including public and international perception. The attitude of some of us in the justice sector is sometimes less than salutary, and that has, to a large extent, contributed to the current image deficit of the country's legal system. Forum shopping by some of our legal practitioners is rampant. It is such acts that often give rise to the emergence of conflicting orders by courts of coordinate jurisdiction. I would like to state clearly that henceforth there will be consequences for any act of indiscretion that could bring the judiciary to disrepute. We have rules and ethics guiding the practice of our noble profession, and we must work assiduously to abide by them and always do what is right in the eyes of the law. Under my leadership, the judiciary will adhere to the principles of honesty, transparency, and integrity. I call upon all judicial officers and members of the bar to join me in achieving this goal. The independence of the judiciary is always a topical issue. Let me categorically state that the Nigerian judiciary is independent in conducting its affairs and rendering decisions without interference. At the Supreme Court, for instance, our judgments are free from external influence. While it is essential for the judiciary as a third arm of government to maintain good working relationships with the executive and legislative branches, this should not be misconstrued as subservience. The issue of the salaries of judicial officers, which has for a very long time occupied the front burner of national discourse, has now been addressed through the concerted efforts of many stakeholders, culminating in the unanimous passage of the Judicial Office Holders' Salaries and Allowances Bill by the 10th National Assembly. His Excellency, the President and Commander-in-Chief of the Armed Forces, Senator Bola Ahmed Tinubu, GCFR, gave his assent to the bill on Tuesday, 13th August 2024. With this significant development, we now have in place the Judicial Office Holders' Salaries and Allowances, etc. Act 2024. This significant milestone has empowered every judicial officer in Nigeria to make more meaningful contributions to national development. Nevertheless, it is necessary to continuously review the welfare package to meet changing economic trends and address pressing infrastructural needs of our courts. While current judicial officers may benefit from some of the reforms, those who are transitioning out of service or have already retired are often left without adequate support, especially in terms of health care. The lack of access to proper medical care has had a profound effect on both serving and retired judicial officers. many of whom face severe health challenges with limited assistance. This issue is equally concerning for those who are nearing retirement as they confront the reality of insufficient healthcare provisions once they leave active service. The rising number of deaths amongst serving judges and justices, as well as retired justices and judges soon after retirement, underscores the gravity of this situation. Addressing these gaps by ensuring access to comprehensive health care and improved infrastructure for both serving and retiring judicial officers and staff is crucial to preserving the dignity and well-being of those who have dedicated their lives to serving the judiciary. It is imperative for the judiciary to uphold the tenets of the Constitution, which remains the supreme law of the land. The rule of law, as the cornerstone of every functional democracy worldwide, should be strictly adhered to in all our undertakings. We must emphasize the importance of this principle to citizens at all levels, encouraging them to actively walk the path of legality and justice. The rights of every Nigerian must be vigilantly safeguarded against oppression and impunity, utilizing the full array of legal instruments at our disposal. Furthermore, obedience to court orders is non-negotiable. No individual or institution, irrespective of their standing, will be permitted to treat the judgments of our courts with levity or disregard. The judiciary stands resolute in ensuring that the sanctity of our legal decisions is upheld. All hands must be on deck in fostering an unwavering commitment to the full enthronement of the rule of law. Disobedience to court orders or non-compliance with judicial directives is a direct affront to democracy and an invitation to anarchy. As such, it is critical that we respect and observe all the features of an enduring democracy, for in doing so, we maintain the delicate balance that sustains our society. Let us therefore work collectively and tirelessly to ensure that Nigeria continues to abide by the rule of law, upholds the best democratic practices, and remains vigilant in the protection of her citizens' rights. No doubt, the effective administration of justice has always been a pivotal concern in our legal landscape, and recent efforts to modernize the system are crucial in addressing its persistent challenges. Central to these efforts is the enactment of the Administration of Criminal Justice Act, ACJA of 2015, which has been domesticated in various states in Nigeria. However, despite its potential to modernize the administration of justice in the criminal justice sector, key provisions remain underutilized and its full impact has yet to be realized. One major area of concern is the recurrent practice of arraigning suspects in court without proper preliminary investigations. In many cases, efforts to gather evidence are only initiated after trial has begun. This backward approach to criminal prosecution significantly delays the process and undermines the delivery of justice. It is unacceptable that in 2024, we continue to see such practices which contribute to the overwhelming backlog of cases in our courts and ultimately erode public confidence in the justice system. The CJN, however, provides solutions to some of these problems if fully implemented. For instance, Section 15, subsection 4, mandates that a suspect's extrajudicial statement must be made in the presence of a legal practitioner of the suspect's choice, or where the suspect is unable to secure one, in the presence of an officer of the Legal Aid Council. Additionally, the Act requires that the entire process be video recorded. These provisions are designed to ensure transparency and fairness in the treatment of suspects, reducing the risk of coerced confessions or procedural abuses. Unfortunately, many law enforcement agencies and prosecutorial bodies have not yet embraced these critical safeguards. The failure to adapt these measures exacerbates delays and inefficiencies, resulting in prolonged detentions and frequent adjournments due to inadequate evidence. Full compliance with these provisions of the CJN would not only streamline the investigative and prosecutorial process, but also enhance the credibility and integrity of the criminal justice system. The effective implementation of the ACJA and ACJLs in the states must be prioritized. Law enforcement agencies, prosecutors, and judicial officers need to be properly trained and equipped to adhere to the requirements of the Act. In addition, mechanisms for accountability must be established to ensure compliance with these provisions. Beyond the ACJA, other critical aspects of our criminal justice system, including reforms in policing, the legal process, and the protection of individual rights, must be pursued with urgency and determination. These reforms are essential to creating a more efficient, transparent, and just criminal justice system that reflects the needs of a modern society. It is my intention to strengthen our processes, provide speedy and qualitative administration of justice, reinforce our structures from the Supreme Court to other courts of record, and reduce corruption to the barest minimum in the system. The Code of Conduct for judicial officers will be strictly enforced. Similarly, the requisite ethical standards will be expected of the bar. Staff of the judiciary will also be expected to strictly comply with the Code of Conduct applicable to them. I must reiterate that the task of cleaning the audience table is a collective one, and my commitment to it is unwavering. I assure you that I will pursue it vigorously. The Supreme Court Rules 2024, which came into effect on 1st August 2024, introduced innovative provisions to enhance the efficiency of justice delivery. For instance, the rules provide for an automatic extension of time to file certain processes in the first instance for the same period without penalty, and in the second instance with the payment of a penalty in default. Thereafter, no further extension of time will be allowed except in an appeal against the death penalty. This innovation eliminates applications for extension of time to file processes which hitherto unnecessarily clog the court's docket. The period provided for the filing and exchange of briefs has been reduced, while greater responsibility is placed on legal practitioners in certain regards to ensure the speedy hearing of appeals. A notice of non-contention must be filed where a party does not intend to contest the grant of an application. Where service of a process is effected on a legal practitioner who has ceased to appear for a party, failure to inform the court expeditiously will be deemed an act of professional misconduct. Furthermore, where costs have been awarded against counsel personally as a result of abuse of court process, he shall file a certificate of compliance within 90 days of the order, failing which he will not have the right of audience in any superior court of record until compliance. Where costs are awarded by the lower court, they must be paid into an escrow account in a commercial bank in the name of the chief registrar. A certificate of compliance duly verified by the registrar of the court below must be compiled along with the record of appeal. Failure to comply shall be deemed as failure to comply with the conditions of appeal with the necessary consequences thereto. We have also made significant strides in modernizing our operations through technological innovations. We have now successfully automated the enrollment unit of the Supreme Court of Nigeria in March 2024. All lawyers called to the Nigerian bar can now enroll online. Prior to the automation of the enrollment exercise, physical presence of all lawyers at the Supreme Court of Nigeria for enrollment was a recurrent feature. However, with the new development, the enrollment exercise has now become seamless and less cumbersome, as it can be done with ease from the comfort of the applicant's respective homes. My lords, distinguished invited guests, ladies and gentlemen, I wish to reiterate that the rank of Senior Advocate of Nigeria comes with immense prestige and greater responsibilities. Those conferred with the rank automatically become members of the inner bar and revered apostles of the Temple of Justice. It is an honor no conferee can afford to take for granted. The Legal Practitioners Privileges Committee painstakingly screened and holistically assessed all the documents submitted by the applicants before arriving at its decision. Even though we know that there is no human system that is infallible, at least concerning the efforts put in place by the committee, I can say with all sense of responsibility that they have done a good job. The 2022 guidelines for the conferment of the rank of Senior Advocates of Nigeria require very high standards of merit from all the applicants vying for the award. Every requirement contained in the guidelines was strictly observed before arriving at the final list. There were 127 applicants for the 2024 exercise. Out of this number, 114 are legal practitioners and 13 are academics. The total number of qualified applicants after the preliminary screening was 98. After conducting the specified screening and filtration exercises, which include a number of appearances in superior courts, recommendations by Honorable Justice of the Supreme Court and Honorable Judges of Superior Courts, chambers inspection, approval and eligibility and integrity of the candidates from the Nigerian Bar Association, Body of Senior Advocates of Nigeria, and of course the general public, among others, the LPPC approved 87 successful candidates who by all standards can be regarded as eminently deserving of the rank of Senior Advocates of Nigeria. Out of this number, 86 are advocates, while one is from the academia. This is indeed a great feat. On behalf of my learned brother justices of the Supreme Court and members of the Legal Practitioners Privileges Committee, I congratulate the 87 successful senior advocates that have just been sworn in. Your success did not come on a platter of gold. You have worked for it. You deserve every privilege, honor, and pride that comes with it. As senior advocates of Nigeria, you carry on your shoulders a lot of responsibilities. From this moment, your behavior and general conduct will now be publicly scrutinized by all those who come in contact with you. Watch your utterances, watch your actions, and watch your company, as you now have an even higher responsibility to assist the court in attaining justice, equity, and fairness. You must display enormous integrity, self-discipline, leadership, and high standards of advocacy. The conferment of the rank on you today authorizes you to use the letters SAN as a lifetime appellation after your names. Similarly, it has conferred on you the uncommon privilege of wearing the silk gown and full-bottomed wig. In addition, you now have the enviable privilege of sitting at the inner bar of our courtrooms across the country and having your cases mentioned first in all courts. However, you are reminded that the rank of Senior Advocate of Nigeria is a privilege and not a right, conferred after due deliberations by the Legal Practitioners Privileges Committee. It is a privilege that can be withdrawn if it is abused. As holders of the esteemed rank, a higher level of integrity, ethics, and accountability is expected of you. The young lawyers equally need your mentoring and guidance, while the court needs your erudition, advocacy, and positive contribution to effective justice delivery. It is opposite at this stage to note that the review of the requirements of the rank of Senior Advocate of Nigeria will be a continuous process in order to ensure that the highest standards are maintained. The docket of the Supreme Court is unnecessarily clogged by legal practitioners seeking to attain the rank by making up the required number of judgments from the court, whereas many of the appeals do not contribute to our jurisprudence. I also seize this opportunity to comment on the mode of dressing by some of our lawyers, especially the younger ones, which does not reflect the honor and dignity of the legal profession. I must unequivocally state that any lawyer who does not adhere to the prescribed dress code for legal practitioners will not be permitted to appear in court. Such disregard for professional decorum undermines the prestige and global respect that the legal profession commands. I call upon the leadership of the bar to take proactive measures to properly guide and mentor the young lawyers. They must be continuously educated on the essential standards of our profession, especially regarding dress code and ethical conduct. It is equally important to remunerate your juniors appropriately, as fair compensation is crucial to nurturing talent and ensuring job satisfaction. This responsibility is the first task I'm assigning to both the new Senior Advocates of Nigeria and the leadership of the Nigerian Bar Association, which incidentally is assuming its role at the same time as I take up this mantle. I am confident that together we will succeed in restoring the dignity and reputation of both the judiciary and the legal profession in our country. The Nigerian Bar Association has consistently demonstrated its commitment to the pursuit of justice in our nation. The leadership of the association has fostered a strong and mutually beneficial relationship with the bench, and this is highly commendable. On this occasion, I wish to congratulate the immediate past executive for the numerous milestones achieved during their tenure. One notable achievement is the seamless deployment of modern technology to register all participating lawyers across the country for the 2024 Annual General Conference. Following the successful online election in July 2024, which resulted in the election of Mazi Afam Osigwe, Senior Advocate of Nigeria, as the 32nd President of the Association. This process has once again provided the Nigerian society with a valuable lesson. We are capable of effectively utilizing technology to elect our leaders with transparency and efficiency. I was particularly impressed by the turnout and active participation of legal practitioners at the recently concluded 64th National NBA Annual General Conference held in Lagos in August 2024. The remarkable assembly of such a large number of lawyers under one roof is indeed a noteworthy accomplishment. I extend my heartfelt congratulations to the immediate past NBA President, Mr. Yakubu Mekiao, Senior Advocate of Nigeria, and his team. The quality of resource persons and the thought-provoking papers presented at the conference centered on the theme, Pressing Forward, a National Posture for Rebuilding Nigeria, have undoubtedly reignited our collective resolve to build a prosperous society. I also extend my warm congratulations to the newly elected President of the NBA, Mazi Afam Osigwe, Senior Advocate of Nigeria, and wish him a successful and impactful tenure. We look forward to continued cooperation and collaboration, building upon the solid foundation laid by the immediate past executive. Finally, I wish to express my sincere gratitude to everyone present today for attending this special session to mark the commencement of our new legal year. I deeply appreciate your presence despite your undoubtedly demanding schedules and the change in time for this ceremony.